The Office of the Public Protector has cleared President Cyril Ramaphosa of any wrongdoing in the Phala Phala farm scandal. We speak to legal analyst Mpumemelo Zikalala on the way forward from a legal point of view. Thank you very much for your time this morning. So President Cyril Ramaphosa is taking the independent panel's report on legal review. And here you find opposition parties, including the ATM as well as the Democratic Alliance, taking the Office of the Public Protector's report clearing the president on legal review. What should we understand about both these processes?
I think all the parties which are involved, which are taking these matters on review, they are saying on the methodology that has been used to come to the conclusion something wrong has taken place. And if the correct or the right one had been used, a different conclusion would be arrived at. For example, the president is saying, but look at what the evidence which was in front of you, the instructions that were given to you. You certainly missed the board of what was the intention of the project which was assigned to you. On that basis, your report should be scratched aside and should not be considered. The same would apply to the Democratic Alliance, whoever is aggrieved by the report which was issued by the Public Protector in terms of saying, Public Protector, you use a methodology which is incorrect. Had you considered all the evidence which was placed in front of you, had considered the provisions of Section 96 and the intended purpose, would come to a different conclusion. On that basis, we want the court to set your report that you've done aside, and if needs be, let's start again, or let's get a new report in which is going to consider all the correct things that are in there. But what will matter the most is what the law enforcement agency's report or investigation is going to yield out, which certainly has taken a bit of a long time for it to come to a conclusion.
She also mentioned that she took a look at the concept of abuse of power. However, she says that this is not defined in the Public Protector Act and had to rely on a dictionary for the meaning of that. What should that tell us?
There's again the methodology in which one would attack when taking any matter on review, especially the report of the Public Protector. But for me, it's the understanding of the intended purpose of a section that is there. Now, any legislation or policy is not created just for fun. It is created for intended purpose, and most of the time is to prevent a certain harm from taking place. Now, in the interpretation of all the facts that may occur, because none would be the same, they're not uniform, there are different set of facts that will apply to any of those rules or policies that are there, and in line with Section 96. Then you have to look and say, can you be able to prevent that particular harm from happening? Was the processes followed to the T? Is there anything that can be drawn? The manner in which the conduct of the president, can it be drawn that indeed you've contravened those certain sections? And now, the only thing in which you have to evaluate is the evidence which is provided to you. Whence, in this case, is the evidence that will come from the SCPS and the evidence that will come from the president. And to dwell more further into it, if you have a person who then says, I'm not involved in the day-to-day running, but I do go there and get regular reports, for me, that's none different than a person who's a board member who goes to a certain entity once every quarter to listen what the things are going on there or what type of processes are being done. Secondly, if you look at the manner of providing advice, what sort of advice do you provide, Mr. President? Is it based on operational level or just to hear what has been happening and then it ends there? If that happens, then it means that you are sharing the attention of you as the president with another entity, which is your own private interest and not totally related to what we South Africans expect you to do. You may not get monthly payments or regular payments, but the mere existence of the interest and the growing number, the growing value of the farm that you have, or the interest in the farm being a profitable one, then definitely says to me, you can interpret it in a wider sense of you getting any paid work at which you are doing. So it's all those things in which the Public Protector would have looked at or ought to have looked at. And if any parties are aggrieved, will go to court and say to the court, please settle this dispute for us. We are saying this is how the Public Protector ought to have looked at the matter. The Public Protector is saying another thing and relying on a dictionary for interpretation. Can you please come to our assistance so that we're able to put this matter to bed?
In fact, she also mentioned that the president retains financial interests in Tabanyoni and he's more actively involved in management of close corporation more than what he appears to be letting on. But she also made it clear from the jump that she was dealing with three issues. The first being, did the President of the Republic of South Africa, Cyril Ramaphosa, act in a manner inconsistent with his office in dealing with the alleged housebreaking with intent to steal foreign currency at his Phala Phala farm? And she found no basis to conclude the president contravened the executive ethics code. He did not expose himself to risk of conflict of interest between the constitutional duties and private interests. However, he's only cleared in terms of EMEA. There's nothing stopping other agencies who are yet, like the South African Reserve Bank, to come out with a different conclusion. You've got some sectors of society believing that the Office of the Public Protector jumped the gun in releasing this report before the SARB releases its report. Is that a fair assessment?
Not necessarily. Remember, these are two independent bodies which are not working in cahoots with each other. So their independence even means that if one report comes from another one at a different amount of time, it does not matter. What matters the most is what type of methodology to be used. What's the science behind the report that you have arrived at? What evidence did you look at? You have your own powers as the Public Protectors Act and other applicable legislation. Let's look into that and then assess. Have you conducted your work in a manner in which it is in line with the powers that you were given? Now, I'll come back to the point that I made earlier. You can't conduct this part of the investigation without looking at the intention of the rules which are there. In this case, Section 96. So, if you are going to have a president who has their own personal individual, whether authorized or not authorized, going to another country to conduct an investigation, it's a question that is something that should be questioned. If you're going to have a president who, in his reporting of a certain crime that has occurred, will not go to a police station like you and me when we've been burgled, will go to another process and allow the particular process to take through, in which ostensibly corrected, where there's no even a case number is created only after a while, then the question would be, would you and I have the same privileges of being able to do that? If the answer to that is no, then there's definitely some sort of alleged or abuse of power. What I would have understood would have been, in the act of the president that were bona fide, they may have been, if you look at it, certain contraventions that may have taken place, however, they were not intentional. They were simply incidental and there was no harm which has been suffered, in line with what the prevention which has been sought by the applicable legislation is looked at. So, yes, if in the face of it, it may look as if there are certain contraventions. However, if we delve deeper, there's no contravention that has taken place, so there's no benefits or fruits that have been derived from the contraventions, which is what Section 96 would have sought to prevent. On that basis, maybe the report of the Public Protector could have been more accepted. But if you look at the technical requirements, the technical definitions, and you simply apply those, you may miss the point as to the intention of the legislation as to why it was created. There are no facts which are going to perfectly fit in your assessment, and definitely you are going to find other factors that you must consider. And maybe use your discretion here and there, but your discretion will be guided by the intention of the rules which are created.
The Office of the Public Protector found that members of the police acted improperly in investigating the break-in at Phala Phala farm, including Wally Rueda. And so what is acting improperly? Was the law broken? Did they break the law? Is that what that means?
Now, even the concerned SAPS would then say, if I've done something wrong, then I think the IP should be the one who are going to investigate me. As you as the Public Protector, you have the requisite knowledge as to how investigations are supposed to be conducted, or to simply look at manner and ways in which government departments have acted. So it's one of the points that may come in. Now, the acting improperly could be, well, you did not follow the normal procedures when it comes to opening cases, but the same could be said by the president. If you open a case, you go to the police station, you write your own affidavit. If you are an interested party, and then once you have done it, you are given the case number. If it's the case that it ought to be the manager of the farm that ought to have done that, then you simply follow the rules of whether that has been conducted or not. And if things have not been done correctly according to the law, then there may be an appropriate body to further look into it. And if you jump the gun and come to certain conclusions on that, you are more or less complicit to what you are accusing the other party of doing.
Ironically, the acting public protector alongside Chief Justice Raymond Zondo were conducting interviews for the next IEC chairperson, and she asked one of the candidates what her understanding is of an independent institution, or the IEC being an independent institution. Could the Office of the Public Protector, following this report, cast aspersions on its independence? Is that an argument that is likely to be made in court, and what standing does it have? Mr. Zikalala, are you with us?
I can hear. I lost you a bit there.
Okay. So the acting public protector and Chief Justice Raymond Zondo were leading interviews for the IEC commissioner process, and she asked one of the candidates her understanding of an institution being independent, more so the IEC. Could this report cast aspersions on the independence of the Office of the Public Protector? Is that an argument that is likely to be made during these review processes, and what standing does that argument have?
You may see those, especially those who are going to be aggrieved in saying, well, let's look at the situation and the facts on the ground. You do have a vacancy which is going to appear within the Office of the Public Protector. As an acting one, you stand a better chance, or one of the chances if you are going to apply for one. So it could be, even though not substantiated, be arrived at that maybe you are creating a special ground for you to be appointed at the end of the day. But for me, that wouldn't be a plausible or even a tangible argument. In fact, it would be very weak, and I don't think any of the parties that seek to take this matters on review ought to even use it, because it simply means that a person is being petty and would make those allegations based on something which is not tangible, and there's no real evidence that you can be able to exert or maybe provide in saying that the independence of the public protector has been done away with, or the public protector, acting public protector's allegiance is attached to someone else. What you should do, if you want to make sure that you're able to win in these particular proceedings, is to then say, let's look at the methodology and the processes that you have followed. Let's look at the facts that were in front of you. Let's look at the law in which you're supposed to test against. When you applied those, what type of interpretation did you use? Did you use tangible sources, or did you use sources which cannot be trusted? Are there any other materials that you could have looked into, for example, case law, that would have been able to better explain the reasoning of to why we've arrived, or our courts have arrived at certain conclusions? And then lastly, don't forget the intention of why the rules are there, and look at whether those particular the intentions have been achieved or not. And do not be scared or to admit that, yes, on the face of it, it may look as if a controversy has taken place. However, there are no fruits or interest or benefits that have been derived, so it can't be concluded that the president had the intention of breaking this particular rules.
In fact, she did mention that she relied on some case law. Is this not a precedent-setting case? Have you seen something like this before? Is there case law that you can think of that she would have relied on to come to the conclusion that she did, or the office to come to the conclusion that it did?
Now, because there has been case law before dealing with the Executive Ethics Code, I think the Public Protector would have dwelt into that and said, let me look at what the Constitutional Court, for example, was saying according to the duties and the manner in which all these processes should be. While if you look at the Concord, it would be much safer to do that, because once the Concord has decided, all the other courts have to abide with what the Concord has stated. So in instances of doubt, in instances of disagreements or narrow, wider interpretation, run to the Concord or go to the case law as received by the Concord, and then you'll be able to get your answer. That's not an abnormality. In fact, it assists you in the methodology which is important, which you've utilized, which becomes more important when your matters then being sent on review, because one of the things which are going to be attacked would be, as you've arrived at this particular conclusion, which route did you take? Did you take the correct one? In taking that particular route, what factors did you look at? Are there any other factors when introduced to the conclusion would lead to a different conclusion? If the answer is yes, why did you leave them out? And if it is discovered that you left them out deliberately or negligently, then it renders your whole report as something that cannot be relied upon. And it's in those instances in which reports such as these ones are then set aside. So it is not an abnormality for a public protector to use case law. In fact, it's advisable. It's just that in the use of that case law, just be careful to make sure that you are able to include all the other case law that may even not favor you, so that you are able to do the extraction process in a much more clearer sense.
Mpumemelo Zikalala is a legal analyst. Thank you very much for your time this morning.